Good morning, everybody. Welcome to the Waterfront CIL Community Infrastructure Levy update. It's lovely to be here. I haven't had to get a train. I've not been delayed. There is, the concern was only whether I would manage to fight my way through the kitchen and pick up breakfast on the way in. So this morning, we would often have been looking at the Community Infrastructure Levy in the annual masterclass sitting in Denton's beautiful offices. But today we are lucky enough to be being joined on this webcast by Roy Pinnock, partner at Denton's, Claire Wood, a planning obligations officer at Sheffield City Council, and Selina Cahoon, barrister at 39 Essex Chambers. I will introduce, I may know many of you, I can't see you this time, but I am Gillian McInnes. I am a planner. I have been involved in the world of CIL since its instigation back in 2008. I used to be with the Planning Advisory Service and I am now a consultant working for many local authorities, often in relation to developer contributions and viability. And I'm currently Head of Planning and Development at Ashford Borough Council, who don't have a CIL, but I might sort that out while I'm there. So firstly, I will introduce Claire Woods. As I said, Claire is going to speak to us about the local authority perspective of planning and the practical considerations when dealing with CIL. Claire has been the Planning Obligations Officer since November 2018, but has been working for Sheffield City Council for a number of years before that in the development management function. So I will pass over to Claire to give us a perspective of the everyday workings of CIL in a local authority. Claire.
Hi, thank you, Gillian. As Gillian said, I'm Claire Woods. I'm the Planning Obligations Officer for CIL and Section 106 at Sheffield City Council, and I've been in post for approximately 19 months, but I was previously involved in the implementation of CIL from an admin perspective. So today they've asked me to give a presentation and a talk on a local authority perspective with regard to Section 106 and CIL and the coronavirus. So as a local authority, there are practical considerations needed to be made in regard to CIL instalment policy, CIL enforcement, CIL relief, particularly exceptional circumstances relief, Section 106 and the infrastructure funding statement. So with regard to the instalment policy, the consideration is whether to amend or to not amend. I know that there's been a lot of discussion amongst my CIL colleagues and that some authorities have been very reactionary in amending their instalment policy, but this might not be the way forward for all collecting authorities. And for those that haven't amended their instalment policy, they need to consider whether this is the right thing to do at this moment in time. Considerations around amending the instalment policy are that it only allows the changes of new planning decisions from when the instalment policy is implemented and doesn't allow it to be applied retrospectively to due or outstanding payments. Also, in accordance with Regulation 69B, the policy needs to be published on the website the day before it takes effect and be available for inspection in its principal office. The latter may not be possible due to the principal office not being open to the public and the former delayed due to resources. Therefore, is there a need to relax this requirement? Implementing a new instalment policy changes it for all developments, but not all developers may be affected by the instalment issues caused by the coronavirus, as they may be financially more robust or have relevant funding in place. And therefore amending the policy would delay payments that could have been paid and therefore could potentially delay delivery of infrastructure. Therefore, is deferring by using discretionary enforcement an alternative to changing your instalment policy as this will deal with payments due or outstanding, whilst allowing developers who can pay in accordance with the current instalment policy to do so. Although payments due or outstanding would all be subject to late payment interest. This moves me on to enforcement. The discretions with which collecting authorities deal with late payment of CIL isn't changing. However, use of discretion is being encouraged in the latest CIL guidance. Under Regulation 85, a collecting authority can choose to impose a surcharge on a person that has not paid CIL. Therefore, they can choose not to impose the surcharge for late payment. If collecting authorities have discretion to impose it, the question must be asked, do they have the discretion to remove a surcharge already imposed? In accordance with Regulation 87, collecting authorities must apply late payment interest, which accrues automatically, starting from the day after the payment was due. Currently, authorities have no discretion to disapply late payment interest. The lack of discretion seems unhelpful in this current situation. However, the latest CIL guidance states that the government will introduce amendments to the CIL regulations to temporarily disapply late payment interest and to provide discretion to return interest already charged where they consider it appropriate to do so for developers that have an annual turnover of less than 45 million. Therefore, will there be a requirement in the amended regulations for developers to state what their turnover is? The timeframe for amendments will impact on how much has to be refunded. Refunding is an additional process for collecting authorities, which will mean additional resources and costs. CIL stop notices. Normally, a collecting authority might consider issuing a stop notice to stop development until the outstanding amount is paid, contravention of which is an offence. Therefore, collecting authorities' decisions regarding whether and when to make such enforcement actions need to be considered under these circumstances. Selina, who's next up, is going to be picking up some more of these points, and we will be happy to take questions afterwards.
It's Roy here. I've now joined.
Thank you. Thank you, Roy. Claire, carry on.
All right, okay.
Sorry.
CIL relief, exceptional circumstances relief. This is a discretionary relief, and not all collecting authorities offer it. We are one of the few that do, and it may be something that authorities want to consider depending on what effect coronavirus has on viability. Our experience is that there is limited guidance on exceptional circumstances relief, and therefore it can be resource intensive and a lengthy process, making sure that it is fully auditable. Section 106 planning obligations. With these, we have greater flexibility than CIL. Therefore, the recent guidance encourages local authorities to consider whether it's appropriate to allow the developer to defer delivery. It's important that local authorities allow time for resolution before instigating enforcement proceedings and take a pragmatic and proportionate approach to enforcement where cash flow is an issue to avoid stall sites and where CIL developers going out of business. Although this can be done informally to a certain degree, a backstop date is recommended, and this can be implemented by using a deed of variation. A deed of variation allows the alteration of timing of payments if right now is not a convenient time to pay. And finally, the infrastructure funding statement. How will authorities meet the requirements of Regulation 121A2 by publishing their first annual infrastructure statement by the 31st of December 2020? Due to the impact of coronavirus, is there any proposal to move this date? It is a difficult time to be making local authorities make decisions on their self-funding priorities. Plus, with the disruption caused by having to set up staff with home working and not having full staff capacity due to other factors like childcare, homeschooling, sickness, etc., local authorities may struggle to collect all the required information in this time frame, so assistance with this would be welcomed. And that concludes my presentation.
Thank you very much, Claire. And just to say, we hope that you submit your questions, and at the end of all the speakers, we will come back to you and pick out a number of the questions. I will now ask Selina Cahoon, a barrister at 39 Essex Chambers, to speak to us. Selina has been rated by Planning Magazine in their 2019 survey as amongst one of the UK's top planning juniors, and works for a variety of public and private bodies, and does a lot of work on planning and development consents, appeals, but also enforcement, which I think we will be hearing more about in a moment. So Selina, over to you.
Good morning, everybody. Thank you very much, Gillian, and also thank you, Claire. Let's just make sure I can, there we go. I am going to deal with the exercise of enforcement of CIL. It's going to overlap a little bit with some of the things that Claire said, and I'm going to also touch on the recent C19 guidance, because that's going to be something that we hope will help a bit for both sides of the equation in taking CIL forward. But what I will do first is just go through the enforcement provisions, some of which will be more familiar to you than others, no doubt, and also then just turn a little bit back to the government guidance and the issue as to whether there may be some relief possible, and indeed I'm also going to touch on exceptional circumstances. So don't worry, I'm not going to completely repeat what Claire said. So dealing first with the provisions, the principal enforcement provisions under the CIL regulations are under Part 9. The first part deals with the issues that we will probably be more familiar with, which is the discretion and issue over surcharges, and then also where it's mandatory. And I've highlighted the two regulations where there's been an update from the 2019 CIL amendments. Firstly, Regulation 83, which deals with the issue of whether you can issue a surcharge for failure to submit a commencement notice. Now, as I said in my, you might have noticed in my first slide, the whole thing with CIL is panic early, but there have obviously, and I suspect that Roy will be dealing with these as well, is that there has been some easing off in terms of the effective commencement and the failure to get all your notices, etc., in assumptions in time, if you are seeking relief. The one issue here under the discretion over surcharge is that it's always a matter of discretion, but in terms of where you've got relevant development, I'm afraid, where it's a relief, there is a mandatory surcharge, but the other side of that particular equation is that you don't lose your eligibility. So it's a little bit of balancing out there. Anyway, just to rush through, well, go through those, the part one on surcharges. Firstly, there's again a discretion as to whether you surcharge for your failure to send your assumption of liability notice or apportionment of liability under Regulation 81. And then also there's a potential surcharge for your failure to submit a notice of chargeable development. The penalty charges under Regulations 81 and 80 and 81 are relatively small. It's £50 under the Reg 80 per person, and 81 to in respect of 80. Sorry, £500 in respect of 81. 82 and 83 are the measures as 20% of the charge, or 2,500, whichever is whichever is the lower. And then under Regulation 85, which is surcharge for late payment, the charge is 5% of the charge, or 2,500, whichever is the greater. Regulation 84 deals with the disqualifying events, which I won't take you through, but there are a whole variety of those issues that you need to be aware of. Lastly, let's turn to Regulation 87 and 88, which deals with late payment interest, as Claire mentioned. This is mandatory. So all of the above, in other words, 80 to 86, are other than a small part of Regulation 83, are discretionary. You have to make a late payment interest. There is no getting around it. And that is the one that we think the government might be looking into and amending under the new regulations if we see them. So the second part of enforcement provisions under Part 9 is stop notices. These are very similar to the procedure under the 1990 Act. You have to have a warning notice under Regulation 89, and it specifically uses the language that we're familiar with from 1990 Act, which is expediency. So it has to be expedient in the councils and the chargeable authorities' view that stopping a development from continuing in the absence of payment is expedient. Thereafter, you have to make sure you've served your notice properly, and again, if the warning notice is not taken up and attended to, then you have a further discretion whether to serve the CIL notice, stop notice itself. You have to put reasons, again, very similar to enforcement, you have to put reasons as to why you have served your notice. It's not the same as expediency, but you certainly have to have reasons for serving a stop notice. It's interesting, the language from the PPG, it talks about the enforcement provisions generally under the CIL regulations as being proportionate and really only where there are persistent offenders. It doesn't use the term offenders, but the guidance seems to suggest that authorities should not be using any of the enforcement provisions where they have a discretion unless they really think that there is somebody who is really being culpable and taking the mickey, as it were, out of the system. I'm not sure that actually comes through the legislation, so that is a matter for each different authority. There is, of course, still the issue of discretion. You must withdraw your CIL notice stop notice when the money has actually been paid, and clearly there are provisions under Regulation 92 where you have a register of the stop notices. So there's no getting around it. If the development has been served with a stop notice, that is something that can be checked on by those who are looking into your development should you be wishing to sell the land. It's an offence to contravene the stop notice, and the penalty is a fine. It's not specified, but will be a matter of you take into account any benefit you've had from continuing to contravene the stop notice. And lastly, it is possible to enforce by injunction under Regulation 94, again very similar to the 1990 Act, where you have to look at enforcement issues. There has to be, again, back to expediency for any actual or apprehended breach of a stop notice, and it has to also be necessary. So there are certain hills which charging authorities have to climb in order to get those injunctions. So on to the third part of Part 9, Part 3, recovery of CIL. So these may be the less familiar terrain for those of you who are having to deal with CIL. These are the sort of these are the sort of the tax-based enforcement procedures, and the main change that came from the 2019 amendments to the CIL regulations was an introduction in England to the removal of distress as a process. It's very similar, but to enforcement under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. It's a familiar system in England, and it clearly relates to being able to take payment through taking control of goods and the goods of the person who is failing to pay. It's a very similar process to distress, but it is a sort of well-worn, well-known procedure in England. So let's go through quickly the recovery processes. Firstly, you can serve a liability order under Regulation 97. Again, this is discretionary, and you have to begin rather like stop notices with a reminder notice that you are required to pay your liability, and thereafter, if you fail to do so and you fail to attend to it, then you can have a liability order. Regulation 98 I've touched on already. Again, if you fail to attend to your liability order, then that can be enforced through Schedule 12. And clearly there's a possibility of appeal in Wales, because in Wales the distress is still the procedure. So Regulation 99 only applies in Wales. Regulations 100 and 101, the differences, as I've noticed there between England and Wales, only reflect the Schedule 12 procedure process. But again, if you fail to attend to dealing with your liability order and you've not paid up, you can be committed to prison for up to 3 months. That penalty is not a new one. It's always been up to 3 months, and it remains the same in Wales. There are various provisions under Regulation 102 as to the nature of the tribunal. Under 102, I'm not going to dwell on that. It differs slightly between England and Wales. And thereafter, Regulations 103 and 104 deal with charging orders. Now, of course, that is another way of making sure that the charging authority gets paid. And it ultimately includes the most familiar thing of putting a charge on the land charges. Insolvency, that is also a further possibility where you can push for that as a charging authority in order to ensure payment. And 106 and 107 deal with, so 107 deals with the enforcement of the local land charges in a very familiar way, but also you can go for a recovery in a court of for contempt. So that's an alternative for a liability order. These, I have to say, are, as far as I am, from my own experience, it is the less familiar terrain, but you need to be aware of them because they can be extremely effective and also draconian. Now, part 4. There are other provisions that you just need to be aware of under Part 4 of Part 9. Clearly, Regulation 108 deals with where there is death of the person with material interest or who's developing out, and should they die, then the CIL, any outstanding CIL can be sought from their estate. 108A and 108.9 are interesting powers. They're not necessarily the enforcing, but they are the background to any officer who wishes to require information. You can actually seek that, but in particular where you've had a regulation for notice about chargeable development. So there are again, very similar to the 1990 Act, an officer and a charging authority can seek information from the person who is the either material interest or indeed about to commence development. There are powers of entry under Regulation 109, and that can be deployed if you want to check whether the chargeable development has commenced, or indeed if there has been a failure to comply with any information that they want to seek. And what's more, you can also seek a warrant. Well, you have to seek a warrant if what you are dealing with is a dwelling, but you can also seek other powers through the court. A further offence to the one of not complying with your liability order is false information, and Regulation 119 simply gives power to charging authorities to be the prosecuting authority. So again, that may be even less familiar to those of you dealing with CIL, but again, just need to be aware of. Lastly, I'm just going to touch back on what the government said back on the 13th of May. As Claire said, the guidance and the main aim of it was to ease the burden on developers. Now, given that PPG, as I said, suggests that enforcement powers under the CIL regulations are deemed to be proportionate, the guidance seems to be suggesting that authorities have existing powers, really, to, my expression, to be kind to developers who have been put into a difficult position by lockdown. The interesting thing is that it doesn't really deal with exemptions and relief. There is no mention to the exceptional circumstances relief that Claire mentioned, and I'll just deal with that, as I say, a bit later. But it concentrates on the administration part and enforcement. In particular, sorry, let me just, it's coming up. So it deals with 69B, again, as Claire mentioned, which deals with instalment policies. And as she said, you've got to have an instalment policy in place. But that instalment policy needs to have a specific number of provisions to it. And what the guidance suggests is you know, if you've got one, you can change it in order to take account of C19. And Regulation 70 deals with the base case, which is that if you don't have an instalment policy in place, or if there are no instalments as part of your chargeable development, then it's 60 days. So you can see why the government is concentrating on that. The second discretion that the guidance suggests the authorities might look to is obviously in relation to the surcharges that I've been talking about, 85 and 88. So if you have a developer who has simply failed to make a payment, then the government is saying, well, think hard about whether you should actually seek those surcharges. And indeed, you should think hard about whether you should serve stop notices, again, given all the circumstances of the case. And lastly, it says very clearly you should think even harder about whether you really want to prosecute. In terms of interest, it sets out, I've set out there the consequence of the mandatory requirements and how it must be calculated. I'm not going to dwell on that. But lastly, then let's look at what is actually proposed by the government. So it's an overall discretion, we think, to defer payments. There's no particular detail given in the guidance, but it seems to be that there will be more said about the discretion to defer payments. It is principally going to be aimed at the interest provisions when exercising at any discretion, i.e. under Regulation 87, but it will only be aimed at those companies or developers that qualify as small and medium-sized developers. So an annual turnover of less than 45 million. So it may well not affect the greater number of developers out there. So we'll see what good it may do and what help it may present. Exceptional circumstances, as I've said, and as Claire highlighted, Sheffield is one of the few that do actually have an ECR statement in place and policy in place. In London, the mayor certainly doesn't, and the view seems to be that that is based on the fact that the first viability, which is what it's basically related to, should be assessed at application stage. There are various requirements in order that must be met if you are going to get exceptional circumstances relief. The last point I'll make about viability on exceptional circumstances is that there is this peculiar provision and requirement under it that there must be a Section 106 in place. And what it says about that is that it doesn't have to be necessarily part of the reason for granting the development. So it's something to look out for. I think now my time is up, and I am going to then now turn over to.
Hello.
Hi. Thank you very much. I will hand over back to Gillian. Thank you.
Thanks very much, Lena. We'll come back to you. I've picked up a couple of points here, but please, you know, I've got a couple of questions showing at the moment, but do bring more forth if you would. Now over to Roy Pinnock. Roy is a partner at Denton's, where we so often hold masterclasses, or I should say not we, but I feel I've been doing it so long, but Waterfront hold masterclasses on CIL. Roy co-heads Denton's UK Planning and Public Law team and is a solicitor advocate. And certainly Roy and I have been engaged in the world of CIL. As I said, I have been since 2008, and I think Roy has been since 2008. So he is most certainly an expert on the subject and sits on the government's expert CIL panel. I will pass over to Roy to take it away. Roy, take it away.
Thank you very much, Gillian. I'm assuming, give me a thumbs up if you can hear, because I've been having technical problems, so I think we're there. Good stuff, yes. Excellent. Magic of technology. A lawyer and technology, what could possibly go wrong? Well, I'm going to be quite brief here, and hopefully will provoke questions and provoke challenge. So we'll see where we get to in the questions that get fed through. I'm not going to dwell too much on the regulations. They're far too difficult for a lawyer. And so I'm going to look at three things really: the COVID-19 impacts from a CIL perspective, the government changes, which I think have already been outlined anyway to some extent by Claire, by Sabina, and then also areas where I think that other changes are really justified, and sort of practices that we need to adopt probably as an industry in order to keep revenues flowing on the CIL side, keep development moving, etc. So on the first element, really in relation to how does COVID-19 really impact on CIL and why does it matter? Obviously, we've got the obvious points around the cash flow hit that imposes in the progression of development, and the fact that the delays that may have been incurred in actually getting onto site, the holding costs of financing land while it's not actually being developed, because there's had to be a moratorium effectively on development activity, the impact on construction pipeline, possibly even just uncertainty in the actual end market for that product. All of those create a cash flow difficulty that wasn't there when schemes were originally appraised, when they were priced for development viability purposes, but also when they were priced in the other world, dare I say it, in the real world of development finance and funding. And so lumping in a big chunk of CIL on those schemes in a way that possibly wasn't ever envisaged as a development cost on top of other development costs is a challenge. There's an issue that's been prevalent in the discussions in the webosphere over the last few months, and that's been on the technical start side of things, so that people looking to bank planning consents before they lapse, making a minimal start to actually do those, and then triggering CIL liability. And I'll come on to phasing, because I think that is much more of a solution than any of the exceptional circumstances relief, or to some extent the instalments policies. But I suppose one thing I would say from a policy perspective is that we should be careful about giving too many incentives for simply bagging planning consents, and that the incentives that are created, the freedoms and the waivers, if there are any to be given in the CIL regime, should be all about ensuring that progress is maintained on sites, and that investment is put into keeping workforces on site, getting workforce on site, keeping employment running, keeping those Section 106 payments coming, and then ultimately also getting the CIL revenue and getting development built. So we shouldn't just be trying to facilitate technical starts. We should be looking at a way that we can actually continue the development pipeline. The other area where I think COVID-19 is going to have an obvious impact is in relation to CIL charge setting, because many of the rates are going to be to some extent an irrelevance. Retail rates and some of the assumptions behind certainly the more aged CIL charging schedules will be completely wrong. They will be demonstrably unviable. There will need to be a look again at whether those rates are now realistic. And for authorities that have paused their CIL setting, there's probably a headache in terms of potentially going back and doing some further work to make sure that the headroom that's baked into the way that CIL was going to be set is still there. So there's a few headaches on that front, and those are going to have to be dealt with. One of the things which I've always pushed for with government when we've had the chance to speak to them is the ability to do a partial review of CIL. And I believe that there should be a power to partially review charging schedules. It doesn't exist at the moment. The period we're in right now, that's going to be really painful, because reviews that need to be done to one rate or one zone or one strategic site zone, those all have to be done through a review of the entire charging schedule, and that is a waste of time. I do also separately believe that there should be a mandatory review requirement where affordable housing and other deliverables fall below a certain level in particular areas, so that we are constantly looking at whether there needs to be a partial review of CIL. That's a personal bugbear and doesn't really affect this debate. The other element, just on the first point in terms of why does COVID-19 matter, is in relation to vacancy periods. So the ability to accrue the demolition credit, the offset for existing in-use floor space, which satisfies the relevant statutory test as having been in use for continuously for 6 months within the 3 years prior to whatever the first permit date is for the particular scheme or the particular phase. One of the things that will happen is that actually satisfying that test for quite a lot of floor space will be more difficult, because actually there will have been vacancies and there won't have been actual use in the way that the How Hope High Court case demands. And so actually we'll find that there's more schemes probably that were anticipating some kind of demolition credit offset when they were being run through for development finance funding, or when they were being looked at from an affordable housing, from a viability point of view at the application stage. And so I'll come on to in a minute what we probably should be doing about that, but that is also going to be an issue. And as I said earlier, I mean, the cash flow matters because it will be a choice between getting people on site working and keeping the development pipeline going versus pulling stumps from the development industry's perspective at the moment, and it's only probably going to get worse over the next 6 months. The choice is there between, do we deploy capital into cash, which is in short supply than it's been for quite some time? Do we deploy that onto a site where there's uncertainty about what's going to happen? Or have we actually got a few hurdles in our way which really just create an additional disincentive, and instead what we'll do is we'll pull our stumps, we'll leave that site if the consent lapses, so be it. And that takes us backwards in terms of meeting needs. It takes us backwards in terms of infrastructure funding and in all sorts of other ways. And it wastes the time that people put into planning consents, both from the local authority, public stakeholder side, and from the investor side. So that's why it matters. ECR, exceptional circumstances relief, has been mentioned publicly in kind of, as I say, some of the Webosphere stuff, and also here. I think there are real limits to exceptional circumstances relief. Selina mentioned one of them in relation to the Section 106 requirement, although mercifully that is usually in play. But the key issue really is that it's discretionary and that as it should be, but there are real limits in terms of, I think there's a 12-month best before date, and even if you phase the scheme, you've basically got to live with that all the time. And so the ability to actually rely on ECR in order to actually deliver complicated phase schemes, even if it's granted, I think is extremely difficult. So we come on to the government changes, the second part that I said I would cover, and I'll be brief on these because I think they have been covered already. I mean, they've come in two parts really. The first is a reminder, and that is on instalments policies and enforcement. And it's been pointed out to the government at the outset of this crisis that instalments are available where phases have yet to commence. So if you started on the scheme, it doesn't matter as long as there's phases, chargeable development, which have still got to commence. The instalments policies can still apply to those phases. And so one thing that flows from that is that even where authorities don't have instalments policies, they could easily adopt a blanket instalment policy that just simply kicks everything back by 6 months in their area. Now, obviously, there are massive issues related to that. There's huge concerns out there in relation to the liquidity of local authorities, and depriving them of CIL revenue is just further difficulty on that front. I mean, in practical infrastructure funding terms, I mean, I suspect that deferring CIL by 6 months makes very little difference, because it's not like the CIL comes in and then is immediately spent. In a global sort of total finance pot, I can understand why authorities would be, resisting that. So it's not an easy discussion, but I do think that is one option that's available to some authorities, is to simply say we'll put in place a short time-limited instalments policy, and for schemes that are implemented within a certain time frame to encourage people to crack on, then we'll bump out CIL payments by 6 months. Easily done. The other elements in relation to enforcement and under enforcement, which is encouraged by the government, as Selina has said, sort of speak for themselves, and to some extent puff. I suspect that most authorities won't be wanting to allocate resources immediately to enforcement, but will need to in due course. The other strand of the government's change is obviously reform, and these are things which we're told will be included in amendments to the CIL regulations when there is statutory time, effectively, and that's on the deferral, and that's on the interest charge waivers, which currently are not possible, although they're being done on an ad hoc basis. And at the moment, we just need to take a bit of care that you see comments being made fairly regularly that there will be a pause on CIL, there'll be a deferral, and there is no consequence to that. When the interest charge on late payment is mandatory, the surcharge isn't, and there are other elements which are discretionary as well, but there are mandatory elements, and those will need to be applied. The key thing, obviously, in relation to the reform element that the government put forward is the £45 million threshold for developers. It's not clear whether those eligible developers will be looked at on a group or a special purpose vehicle basis. I suspect it'll be a group basis, so we're looking at the small builders. That's part of the wider sort of political lobby around small builders, which I understand, but it kind of also misses the point on some of the schemes where you've got the most people on site, where you've got the most hurdles to actually delivery. You've got some really big CIL bills. You might have a special purpose vehicle entity that's within a wider group structure that's got more than a £45 million turnover. Partly misses the point, fairly unsatisfactory, and I think creates a great degree of uncertainty. And I think just to finish that off, I mean, the key point really is that it will still be discretionary, and so it still requires charging and collection authorities resource to actually consider each case, and in a way that is unhelpful. I think that it would be better to have something which does apply across the board, which is fair and sensible, which then means that authorities don't have to allocate scarce resources to a further layer of decision taking in relation to CIL. Very quickly, because I suspect I'm going to get booted by Gillian in a minute. The other changes that I think that are needed, and these are really quite brief, there's three. My view is that the government should simply put a 6-month deemed extension to the commencement date. So, I mean, if you give a commencement notice and the date then occurs without being withdrawn, I mean, that gets pushed back by 6 months. Likewise, if you have a deemed commencement date during this emergency period, it gets pushed back by 6 months. Easy to legislate for, very simple to administrate, because it will apply. It reflects what's been done in Scotland by the Scottish Parliament on extensions of time limits for planning consents. It's pretty straightforward. I know there will be real issues around monitoring and stuff like that, but it's just another line that gets put in the Excom spreadsheet in terms of date range, I think. The last 2 points, authorities do need to adopt a really sensible approach to phasing. So, I mean, one of the best ways to insulate is to actually just have phased consents, where there is the ability to carry out an initial wave of demolition and enabling works, which don't have any chargeable development in that phase, or rather floor area, and therefore don't trigger a CIL hit. And it's only when the floor space begins to be developed that CIL is triggered. And that's been done fairly consistently across the board. But there's just pushback creeping in, I think, when I've been acting for developers recently. And I have a slight suspicion that that's due to a desire to amass as many CIL receipts as possible, which is perfectly understandable, but entirely wrong. And then I think the other element is just in relation to Section 96A. And there's a recent case which clarifies, certainly as far as I'm concerned, that Section 96A absolutely can be used to install phasing in the scheme, as long as it is not done after the scheme's already commenced and crystallised the CIL liability. And we should be absolutely clear that where there are Section 96As coming in to put in place pretty mundane phasing, which will help schemes get delivered, help schemes get built, then we should do that. And then the final one is just on demolition credit. I think that is an area which there would need to be a sort of 6-month extension or something similar, just to reflect what I said at the outset about vacancy period. I suspect it won't get done because it's too complicated, but there we go. So that's it from me. And if there's questions, then obviously delighted, and challenges, as I said before, then delighted to take them.
Thanks, Roy. Well, we've got just under 10 minutes for questions. We've had a few through. I'll maybe knock off a couple of the quick ones, and thank you all the speakers for joining me again. We have a question about, has there been any news about an update from the government in the timetabling for the infrastructure funding statement? And not to my knowledge, so unless anybody else has that, any knowledge of any update. No, I don't think so. In terms of to Claire, has Sheffield taken legal advice on deferred Section 106 payments? And maybe a broader question for everybody is, what are the alternatives to using deeds of variation in order to secure amended payment dates? And both of those are from Stephen Faulkner.
Yeah, we've taken legal advice. Obviously, you can choose not to enforce payments that are due, but obviously, depending on the legal agreement, there will be interest incurred. Same as CIL, because it's a shall in the deed and not a may. And we're trying to encourage deed of variations where possible, but obviously they can be time consuming to proceed with.
Definitely. There is a question here. If there's discretion allowed for payment under Regulation 87, will it allow the local authority to recover the cost of its capital? In many cases, the local authority will have already committed the CIL payments in its capital programme and will have to borrow in lieu of the delayed payment. So where you're that's from Brendan Troy. So you know, it's the local authority that is coming to the rescue of the development and actually the delivery of the infrastructure. It certainly isn't central government.
So I think what's being asked, is there a sort of quid pro quo if you agree to defer, that there might be some means of recouping back anything that's been spent? The short answer, and heavily caveated, is no, but it would be interesting. I like Roy's idea of being able to have short-term review of your CIL charging schedule, because I can think of many that do need updating, and where that sort of glitch might be able to be addressed. But that's trying to find a solution, but that's not actually within the regs. I don't know whether anybody has any different views on that.
I mean, I think just to come in on that, I mean, there is nothing to stop a deal being done, a separate side agreement, side letter contract, or being embedded in if there is a parallel deed of variation to a Section 106 agreement where those 106 triggers are being modified slightly as part of it, just to include, you know, payment which I suppose is financially neutral for the authority, so that in pushing back, the authority is not losing, and as long as there's a sensible way of sharing information so that the authority's actual loss in doing that is covered, then that's fine. And for the authorities who are committing CIL and who've got the kind of programme that Stephen's referred to, then good on them, and they deserve to be able to do those kind of deals. I mean, there's no problem in contracting that way. Depending on the threshold, there's an issue around state aid anyway, where there need to be care about how assistance is given to developers, and whether there is neutrality for the authority ultimately. So I mean, I think those kind of agreements absolutely should be explored where they're genuinely necessary.
I have a quick sort of question here from Rebecca Martin, just asking the question: is there templates for stop notices for CIL, as she has not seen them, and you know, whether there was anything in government guidance?
Not that I'm aware of, no.
No.
There's
Claire, have you got any experience of that?
I think there are some templates within Exicom. We've only ever done warning notices, which people tend to pay once we do that, so we've not actually issued a stop notice as yet.
So Rebecca, the answer is see if you can have a look at what Exicom have got and see whether it's, check it with your lawyers as to whether it's fit for purpose, or one of these lawyers maybe. So another question. Now this is quite a tricky question. I'm just going to read it because I'm sure I'll get it wrong. It's a general question submitted on behalf of Naz Chowdhury at London Borough of Newham, who's seeking to understand more clearly the process SHR after a development commences under Regulation 51 4A. What type of change is this referring to? Changes after the commencement of development. Now that might be too.
I'm happy to deal with that.
Yeah, you can deal with that. On you go, Roy. Go for it.
In normal sectors, I wouldn't, but given that I was giving advice on it last week, I might even get it right. You never know. So as with CIL, I did understand it once, and it was relatively recent, so I'll try and do this without a cold towel around my head. Yeah, so the CIL regulations very sensibly provide for changes to the amount of affordable housing floor space, qualifying floor space, to be factored in and derive an additional right to get social housing relief. Obviously, as Naz says, the start position is that social housing relief can only be claimed before, claim can only be made before commencement, and then is invalidated if there's commencement before the SHR is awarded. The sub-regulation that's been referred to there allows for development to be commenced, the whole thing gets built out, and then actually you change some of the units so they now qualify for social housing relief, and that primary way of doing that would be a deed of variation, you know, to the 106, which says, okay, well look, and this is happening a bit in the market, that we had 100 units here. We were wanting to sell the last 20 that we already built off for market housing, but guess what? The market's tanked. We've got a registered provider who wants to buy them all in. They'll just buy them. That's fine, and they'll do them as affordable rent. So we've just done a deal with a registered provider. It's a bit less than we thought we'd get, but there you go. It's a block sale to them. So basically, the amount of affordable housing in the scheme has just gone up. All those units are subject to the Section 106 through a deed of variation or a unilateral undertaking if necessary. They therefore qualify, and then that bit of the regulation allows the owner, the developer, to come forward and say, right, well, we'd like some more social housing of these now, please. These now qualify.
Unfortunately, we are coming to the end of our time, but I just thought I would finish with Brendan Troy's made a comment, and I like this. So, you know, it's a bit of a challenge. I don't agree CIL is not committed before it comes in. 100% of Wokingham Borough Council's CIL is allocated out in our, and it's MTFP, so I'm not quite sure what that is, but no doubt something to do with funding. So stopping payments for 6 months would have a significant implication on the capital programme and delivery of infrastructure. Investment in infrastructure is the best way to get the economy moving, and delaying payments could have a negative impact on this.
Absolutely fair point. Yeah,
that is an absolutely fair point. Thank you for the rest of the questions. I'm sorry that we have now come to the end of our time this morning, but I've certainly learned a lot. As I say, I've not been as heavily immersed in the world of CIL, and I'm very disappointed that I don't have a chance to come to another couple of questions, because they looked very interesting indeed. But maybe they will get picked up outside the seminar. But thank you to all the speakers, and thank you to Waterfront for holding this nice little bite of CIL for a morning. And I will say good day to all of you. Back to a world of Teams meetings back to back for the rest of the day.
Thank you very much.
Okay, cheers. Bye-bye.
Bye-bye.